Good afternoon. My name is Palomar Sanchez, and I am the Richmond Rent Program staff attorney. Today is April 28th, or when you will be seeing this will be April 28th, 2023. This PowerPoint presentation is for the workshop titled Understanding Residential Lease Agreements. So without further ado, we will get started. However, I do want to make a small disclaimer that none of this is just an oral disclaimer that none of this is to be construed as legal advice. I suggest that anybody who has any particular legal questions to speak to an attorney. You know, there are some parts of the law that tangentially relate to lease agreements, which I don't cover. This is not a completely comprehensive workshop. So for example, there are certain requirements for like disclosures and mold and certain other areas and, you know, asbestos, but that only applies to certain properties built before a certain year. And so that's why I chose to not include that in today's, in today's workshop. In any event, let's get started. All right, so the topics covered today are, first of all, what constitutes a residential lease? We'll be talking about verbal versus written leases. Then we'll be discussing the breach of lease just cause under the Richmond Rent Ordinance, modifying a lease agreement. There are some California law specific implied provisions in leases which people may not be aware of. We'll discuss some lease breaking statutes, issues regarding expiration of a lease, and then there's unenforceable provisions and automatic renewals, and then requesting a copy of the lease. All right, so let's get started. So what constitutes a residential lease? So initially, a residential lease agreement is a contract. Leases may be sometimes called other things like rental housing agreements, rental contracts, or other similar names. These contracts lay out the rights and responsibilities of the parties in regards to the residential rental. And again, just these are just broad strokes, but in contract, the definition in contract law is there are numerous definitions and ways to describe a contract, but according to Black's Law Dictionary, one of the broader definitions of a contract is where a promise is made on one side and assented to on the other, or where two or more persons enter an engagement with each other by a promise on either side. So just in its most simplistic terms and its most basic terms, a contract is an exchange of promises to perform. And that is particularly true in the context of a residential rental, as you know, there are a couple promises on both sides, both for tenants and landlords when they enter into these types of agreements. So in Richmond, according to the Richmond Rent Ordinance, a rental housing agreement, and this is a specific definition, is defined as an agreement, oral or written, or implied, between a landlord and tenant for use and occupancy of a rental unit and for housing services. And just for everybody's information, a rental unit under the ordinance is defined as any building, structure, or part thereof, or land appurtenant thereto, or any other rental property rented or offered for rent for residential purposes, together with all housing services connected with the use or occupancy of such properties, such as common areas and recreational facilities held out for use by the tenant. And just as a side note, agreements for more than 1 year must be in writing according to California Civil Code 1624. All right. Now, residential, this is continuing on what constitutes a residential lease. Residential leases are unique in that the presence of the original parties to the agreement do not necessarily determine if the agreement is still enforceable. This means that lease agreements are potentially transferable either on the tenant side or the landlord side, either by choice, by operation, or natural consequence of the law. So what this means is that a landlord who originally rented a unit can, for example, sell the property to a new owner, and that lease will remain enforceable. And the new owner cannot claim there is just no agreement, between them and the tenant, or change its terms without consent of the tenant. Now, on the other side, this also means that a tenant who originally rented the unit, and this is just an example, a tenant who originally rented the unit may move out, but the remaining original tenants or occupants, even if not named on the original lease agreement, will still likely be able to use and enforce this original agreement. Now, as stated on slide 4, a lease agreement may be written, oral, or implied. In California, an oral lease agreement carries the same enforceability as a written one, and that's pursuant to California Civil Code 1622. However, if it's for more than 1 year, it has to be in writing, as stated in slide 5. Now, written leases are recommended, as this written document would clarify any rules, requirements, responsibilities, limitations, or agreements for renting the rental unit. If the lease is written, a copy must be provided in the language negotiated. So California Civil Code 1632 requires this translation for a lease, sublease, rental contract or agreement, or other term of tenancy contract or agreement for a period of longer than 1 month, covering a dwelling, an apartment, or mobile home, or other dwelling unit normally occupied as a resident. All right, so now we're going to talk a little bit about just cause, and specifically the breach of lease just cause under the Richmond Rent Ordinance. So under the Rent Ordinance, the language specifically says a landlord can evict if the tenant has continued after written notice to cease to substantially violate any of the material terms of the rental agreement. Now, it's important to understand that this says the tenant must, quote, substantially violate any of the, quote, material terms of the agreement. So, just by natural consequence of the law, then minor violations will likely be insufficient to act as a basis to allege material breach. However, each lease and fact pattern are potentially different. And so in order to, or not the lease, but the fact pattern, in order to, determine if this falls within that category, you will likely, or you should likely speak to an attorney. Under the same section of the Rent Ordinance, there are express requirements to this particular just cause. So first of all, the terms of, whatever the lease term is, or the provision that lease, those must be reasonable, legal, and have been accepted in writing by the tenant or made part of the rental agreement. Now, this is an important part, which we will discuss a little bit later again, but if the terms were made subsequent to the initial creation of the tenancy, the landlord needs to have informed the tenant in writing first that they need not agree to such terms. And then if the tenant agrees, they become enforceable parts of the rental agreement. Now, claims of breach of lease due to subleasing a unit have special rules and may not commence if. And so again, this is if the allegation is, for example, that the tenant is subleasing when you have a provision that says no subleasing. But that particular issue or this particular just cause may not, or an action based on this just cause may not commence if the tenant continues to reside in the unit as the primary resident. The sublease, so that's the main tenant, not the sublease, right? The sublease replaces one or more departed tenants on a one-to-one basis, so meaning that The sublease C is just essentially a replacement tenant, replacing someone who left. And then the landlord has unreasonably withheld the right to sublease following a written request by the tenant. So it's all three of those requirements, by the way. All right. So further discussing this breach of lease issue, the rent ordinance requires that a written warning be issued to the tenant prior to any further action is taken when breach of lease is being alleged. So the rent ordinance states, it's called the written warning notice requirements. Any written notice as described in section 11.100.050 A2, 3, or 4, and I believe A2 is breach of lease, shall be served by the landlord within a reasonable period prior to serving a notice to terminate tenancy, and shall inform the tenant that a failure to cure may result in the initiation of eviction proceedings, of the right to request a reasonable accommodation, and the contact number for the board. The notice shall also include sufficient details allowing a reasonable person to comply. The notice shall also include any information necessary to determine the date, time, place, witnesses present, and other circumstances concerning the reason for the notice. This is important because prior to any allegation or termination notice issued for breach of lease, this says that a written warning notice must be issued prior to issuing that termination notice. And it has to have this information in that notice itself. Now, additionally, we have a regulation which is related to this, which is Regulation 1002, and it states in relevant part that if a tenant violates the material terms of a rental agreement, the landlord must provide the tenant with a written warning notice to cease, as we just saw in our last slide. The landlord must serve the written notice within a reasonable time period prior to serving a notice to terminate tenancy. Now, for purposes of this section, a reasonable time period shall mean either not less than 5 business days, or if it is not reasonable that the time period to cure the violation can be accomplished within 5 business days, the tenant has started to cure the violation within 5 business days, and thereafter diligently pursues the cure of the violation. Now, if the tenant violates the same or substantially the same material terms of the rental agreement within 12 months from the date the tenant received the initial written warning notice to cease, the landlord need not serve a further written warning notice to cease, but may then take action to terminate the tenancy. So a couple things. One, that written warning notice to cease has to provide at least 5 business days generally. And then also, once you issue that notice, it essentially provides you a 12-month window where if the tenant breaches or is alleged to have breached the same violation or committed the same violation within the 12-month period, then you need not reserve another written warning notice, and you can actually just go straight to the termination of tenancy. All right. Now, there is a subpart of this of the rent ordinance, and essentially what it says, or actually what it does say, is that notwithstanding any contrary provision in this section, so you can put aside every other provision for this section. It says a landlord shall not endeavor to recover possession of a renting as a result of the addition to the renting of a tenant's child, parent, grandchild, grandparent, brother or sister, or the spouse or domestic partner as defined in California Family Code Section 297 of such relatives, or as a result of the addition of the spouse or domestic partner of a tenant, so long as the number of occupants does not exceed the maximum number of occupants as determined under Section 503B of the Uniform Housing Code, as incorporated by California Health and Safety Code 17922. So, I think whenever there is the allegation is breach of lease, and then the facts are that that they're breaching lease based on some type of limitation in occupancy, then the landlord or their attorney should may want to understand who those people are, because as you can see here, you may not be able to recover possession if the extra person is, for example, the tenant's child or their parent, right? And so I would definitely speak to an attorney if that's the allegation and review these codes. Now, as a reminder, somewhat separate from this last concept, landlords are also capable of breaching or violating the lease agreement. So should there be a breach on the part of the landlord or their agent, the tenant would be relieved of any further obligations under the lease and could vacate the property. I will explain a little bit on how a landlord can breach the lease, besides kind of simple things, but it is possible. Both landlords and tenants can breach the lease. And finally, claims for breaches of written lease agreements have a 4-year statute of limitations, while claims for oral lease agreements have a 2-year statute of limitations. And there could be other limitations subject that this would be subject to, depending on the action and claims made in the case. Now, modifying the lease agreement. So because a lease agreement is a contract, generally, it cannot be changed without express written agreement by both of the parties. Now, when the landlord wants to change a part of the lease, they must first propose the change in writing, and the tenant needs to accept the changes. So, of course, I think I mentioned this in a previous slide, but again, I'll read it off. According to Richmond Municipal Code 11.100.050A2, where such terms have been accepted by the tenant or made part of the rental agreement subsequent to the initial creation of the tenancy, the landlord shall first notify the tenant in writing that he or she need not accept such terms or agree to their being made part of the rental agreement. And so, landlords have to provide this notice and say, hey, I want to add this to, or I want to make this change to the rental agreement. You do not have to accept it or agree. And if you do, though, it can be made part of the rental agreement. Now, there is a general exception to the above requirements for changing the lease agreement, and that is when the landlord has a lawful right to increase the rent, and they do so properly. So, for example, after the first year of a lease, and it becomes, let's say, month to month, a landlord may be able to increase the rent with proper written notice after that initial year without actually changing the lease agreement, right? Originally, the lease could say, $2,000, but then let's just say they have a right to take an AGA after that. There's an exception to changing the agreement, because obviously the rent is no longer what it originally was in the original lease. It's changed. But like I said, there's a bit of an exception there. All right, so now we're going to discuss some implied provisions in California law. So first of all, and this is related to the breach issue on the part of the landlords, I'll explain at the end. So the implied warranty of habitability is a legal term which has been developed and defined through various court cases. The California Supreme Court has expressly held that the implied warranty of habitability exists in all residential rental agreements, and there's a specific court case there that is cited. This means that it is the landlord's duty and promise to provide tenants with safe and sanitary housing as defined in Civil Code 1941.1 and Health and Safety Code 17920.3 in exchange for collecting rent. And that's a promise that is implied in the contract, even if it's not stated anywhere expressly in the contract. There is also the implied covenant of quiet enjoyment. So in every California residential lease, there's an implied covenant of quiet enjoyment, guaranteeing that tenants will be able to peacefully enjoy their homes. So you can see that that's all. There's a specific civil code that is references this law. This quiet possession includes two requirements. First, the landlord may not take an action that substantially interferes with the tenant's lawful use of the home. And second, the landlord must take action to provide a tenant with the quiet enjoyment or quiet possession of the tenant's home if the landlord is aware that the tenant's lawful use of the property is jeopardized. Now, this brings us to, again, this is part of any California residential lease agreement. It's embedded in there. It's an implied part of it. It doesn't have to state it anywhere. Now, this goes to the part where landlords can potentially breach the agreement in that if, for example, the implied warranty of habitability is violated, clearly, then that alone has allowed therein lies the breach of the lease, right? Because it's embedded in the lease. Landlord didn't follow it. Now you have a breach of the lease. And therefore that, would potentially relieve the tenant's responsibility to fulfill any further requirements on that lease agreement, and they could leave. All right. Attorney fee provisions. I don't think many people talk about these, but this is an important aspect. So first of all, attorney fee provisions are pretty common in lease agreements. I don't think many people really think twice about them, but you should know a few things. So first of all, in any, there's a specific civil code that talks about attorney fee provisions. It's California Civil Code 1717, and it says, in any action on a contract where the contract specifically provides that attorney fees and costs which are incurred to enforce that contract shall be awarded either to one of the parties or to the prevailing party, then the party who is determined to be the party prevailing on the contract, whether he or she is the party specified in the contract or not, shall be entitled to reasonable attorney's fees in addition to other costs. So what does this mean? This means that both landlords and tenants should review their lease to determine if an attorney fee provision, I should say provision, exists in the lease. If it does, that code means that either party may be responsible for the other side's attorney fees if they lose a lawsuit based on the contract. This could be an unlawful detainer or an affirmative lawsuit against the landlord by the tenant. So again, this code says, so for example, some attorney fee provisions could say, well, if the landlord wins, prevails in a court action based on this agreement, then they will be entitled to attorney's fees. This code says that's not how it works. If you have a one-sided attorney fee provision, say for the landlord or even for the tenant, it doesn't matter. It's now a two-way attorney fee provision, and both, either party could be responsible. Now, if it does not contain a attorney fee provision, then neither party is responsible for any attorney fees the other side may have incurred. And finally, if the lease limits the amount of recovery for attorney fees, sometimes they say, limited to $500, then that is the maximum either party may be charged if they are found liable for the other side's attorney fee. All right, so now we're getting into lease breaking, which is it's not an embedded or hidden or implied provision, but it's something to be aware of. This is under California Civil Code 1951.2. So if a tenant breaks the lease, they may be liable for unpaid rent remaining on the lease, but only if, and this is all outlined or mainly outlined in this civil code, so only if the landlord attempts to mitigate unpaid rent damages by making a reasonable effort to re-rent the unit and the unit remains without a sitting tenant. In other words, if a tenant breaks the lease, the landlord cannot make the tenant pay for the remaining unpaid rent unless the landlord can show that they made a reasonable effort to re-rent and were still unable to find a replacement or a new tenant. And by the way, they can't just charge, let's just say the tenant breaks at least 6 months into a 1-year lease. They can't just say, oh, well, I've made my reasonable effort, now I'm done, and I'm charging you for the last 6 months or 5 months or whatever is left. And that is because and that's the third bullet point here, once a new tenant occupies the unit, a previous tenant's liability for rent is over. They have to find a new tenant now, and it's really month by month, right? Like whenever the original due date was for the rent, that's when they can charge if there's no sitting tenant. But again, once the new tenant occupies the unit, that previous tenant's liability for rent is over. There's a specific civil code which prohibits landlords from charging for the same unit on 2 different tenancies. So you cannot do that. Now, some events do not allow a landlord to charge for a tenant breaking a lease. There are numerous ways. There's several, I would say, not numerous, several. But some examples of this include being called to military duty. So that's under the Service Members Civil Relief Act, or being a victim of domestic violence, elder abuse, or human trafficking, and that's under Civil Code 1946.7. So if you are, for example, a victim of domestic violence, you cannot be held liable for leaving your lease. You are insulated from that type of liability. And finally, remember that landlords are also capable of breaking, or in other words, violating the lease. And that's what I was discussing in the previous slide. All right, expiration of a lease. Please note that under the Richmond Rent Ordinance, mere expiration of a lease is not a just cause to evict. Again, it is not a just cause to evict. So simply because a tenant's lease expires does not mean you can evict in Richmond. Also, failure to sign a new lease agreement upon expiration of the previous one is not a just cause to evict. So let's just say that the landlord wanted the tenant to re-sign and said, if you don't, I can evict. That's not correct. You cannot force them to. And in fact, once rent is accepted after the expiration of the initial term and no new lease is signed, the tenancy automatically becomes a month-to-month tenancy. So Civil Code 1945 states that if a lessee of real property remains in possession thereof after the expiration of the hiring and the lessor accepts rent from him, the parties are presumed to have renewed the hiring on the same terms and for the same time, not exceeding 1 month, when the rent is payable monthly, nor in any case 1 year. Thus, after that initial term and then there's rent paid, now it's a month-to-month automatic tenancy. And so, finally, even if a lease expires, the enforceability of its terms, besides the length, right, the original term length, remain intact. So, once a lease term expires, does not mean that all the rules and requirements just go out the window and you can do whatever you want. Those rules still apply. It's just that the term has just changed. That's all. All right, so these are some examples of unenforceable lease provisions. Landlords cannot put in a lease or put in a lease any provision which is just illegal and therefore unenforceable. And so in the Richmond Rent Ordinance, so any provision in lease which removes the tenant's right is void as against public policy. So the Richmond Rent Ordinance says any provision, whether oral or written, in or pertaining to a rental housing agreement whereby any provision of this chapter for the benefit of the tenant is waived, shall be deemed to be against public policy and shall be void. So say, for example, a provision in the rental agreement, it says, this rent unit is not subject to the rent ordinance just because I wrote, because they wrote it in the contract. Well, that is an unenforceable provision. Cannot do that. Some other examples of this. So again, any provision which self-exempts the property from rent control or eviction protection. Any provision which allows a landlord to terminate a tenancy with a 30 or 60-day notice. Again, without just cause, for example. Any provision which deems a security deposit as non-refundable, or any other money like that is non-refundable. And any provision which conflicts with the law. That's pretty clear. And again, any of these types of provisions will be unenforceable. And by the way, if a rental agreement does have a provision which is illegal, a single provision, for example, the rest of the contract is not necessarily void. More likely, that single provision is void. However, the remainder of the contract is likely to be enforceable. All right, just a last couple notes on, first of all, automatically renewed leases. So for a lease, for example, a 1-year term lease to be extended automatically, and I have seen these, they do exist. And so some landlords may use these, but there are some requirements. And so for a lease to be extended automatically, if the tenant is still in possession or did not give a notice of termination, the extension clause must follow the requirements of Civil Code 1945.5, which states, and you can read that on your own, it's kind of a little long, but essentially what it says is that for an automatic renewing lease to be enforceable, the automatic renewal provision, the section that says this is an automatically renewing lease, must, 1, appear in the body of the agreement in at least 8-point bolded font and appear immediately prior to the place where the lessee, the tenant, executes the agreement, again, in 8-point bold font. I should have typed that in there, but it's both wherever it is in the body and again, where they sign the agreement has to be in at least 8-point boldface type. Finally, requesting a copy of the lease. So California Civil Code 1962, Section A states that any owner of a dwelling structure specified in Section 1961 or a party signing a rent agreement or lease on behalf of the owner shall do all of the following. And in relevant part, it says provide a copy of the rent agreement or lease to the tenant within 15 days of its execution by the tenant, and once each calendar year thereafter, upon request by the tenant, the owner or owner's agent shall provide an additional copy to the tenant within 15 days. If the owner or owner's agent does not possess the rental agreement or lease or a copy of it, the owner or owner's agent shall instead furnish the tenant with a written statement stating that fact and containing the information required by paragraphs 1, 2, and 3. So again, this means that you can request a copy of a lease, and it is required that the landlord provide a copy if they have it within 15 days. Now further, Civil Code 1962B requires that in the case of an oral rental agreement, the owner or a person acting on behalf of the owner for receipt of rent or otherwise shall furnish with the tenant within 15 days of the agreement with a written statement containing the information required by paragraphs 1, 2, and 3 of subdivision A. Once each calendar year thereafter, upon request by the tenant, the owner or owner's agent shall provide an additional copy of the statement to the tenant within 15 days. Now, for any potential buyers of properties subject to the Richmond Rent Ordinance with sitting tenants, my advice is to make sure to request a copy of any lease agreements that may have been executed in the past. This is because the above law's requirements transfer to the new owner after 15 days of ownership. So Civil Code 1962C states the information required by this section shall be kept current, and this section shall extend to and be enforceable against any successor owner or manager who shall comply with this section within 15 days of succeeding the previous owner or manager. So new owners would therefore be subject to these requirements, and which is why it's important to ask for those lease agreements. Finally, we've been getting questions about this, but I just wanted to clarify that the rent program generally does not require or retain copies of lease agreements. And finally, I just wanted to say thank you. That is the presentation on residential lease agreements in Richmond, or understanding residential lease agreements. And again, my name is Palomar Sanchez. I'm the staff attorney for the Richmond Rent Program. Should you have any particular questions regarding this presentation or any of the information therein, please do not hesitate to give us a call at 510-234-RENT or 7368 to schedule an appointment. You may also email us rent@ci.richmond.ca.us or visit us at www.richmondrent.org. Thank you.